Michigan podcast. I'm attorney Vonda Evans, retired judge, and this is
I am attorney Carla Marable.
Extraordinaire. Attorney Marable, we know that you are licensed to practice in several states. So we're going to talk about specifically Michigan. And in this episode, we're going to talk about self-defense, something that she's very good at. What does self-defense mean in Michigan?
Self-defense is a legal theory that, if used correctly, it excuses you of the conduct that you are charged with. In the state of Michigan, self-defense says that you acted honestly, reasonably, to defend yourself because you felt that you were going to be killed or have great bodily injury done to you or sexually assaulted.
Can a person take another person's life and not go to jail or prison?
Oh, yes, if they have a valid self-defense argument.
Have you ever used this defense?
Many, many, many times. And the thing that I like about self-defense is, in the state of Michigan, it's burden is on the prosecutor to say that you didn't act in self-defense. So the prosecution has to prove beyond a reasonable doubt that you did not in self-defense.
And you've used it. What type of cases have you used it in?
Murder cases, great bodily harm, attempted murder, rape cases where the person was accused of trying to do a sexual assault and the person killed them.
Now, this is where it gets tricky. Does your client have to testify?
That is. So with self-defense, the person has to testify because, remember, the legal argument is that you acted honestly and reasonably, that you were in fear of a great bodily harm, murder, or sexual assault. So you have to articulate what made you think that. Why do you think that the person was going to hurt you?
Oh.
So you always have to testify in self-defense.
Now, we'll just go over what the criminal justice, the jury instruction says. It says that at the time, the defendant must have honestly and reasonably believed that he or she was in danger of being killed, seriously injured, sexually assaulted. If the defendant's belief was honest and reasonable, he or she could act immediately to defend himself, even if it turned out later that he was wrong. Now, that's tricky. Explain that to the viewers. You have an honest and reasonable belief, but what if you were wrong?
If you testify and you make a jury of your peers believe that you honestly and reasonably believe that your life was threatened, you was under great bodily harm, then you are not guilty. Even if it's later come to find out the person didn't have a gun or the person didn't have anything that was going to harm you. It's what you believe at the time that you act in self-defense, which is good for defense because if the person is able to articulate why and what made them act in self-defense, they should be found not guilty.
I used to, when I was a judge, I would give an example. Say, for instance, I'm driving in the back of my house with my daughter, and I have a CPL, and it's dark out there. And as I'm driving, I see a man, and he's got black clothing on, and I see something shiny, and my daughter says, "Mom, he's got a gun." I pull out my gun, I shoot him, I kill him. Lo and behold, it's the DTE man. He was presenting his badge. He was unarmed. Can you still use that defense if it was honest and reasonable, and I later turned out I was wrong? Could you still potentially ask the judge for that defense?
You most certainly can, yes. And that's what it's designed for. The thing that I love about self-defense in the state of Michigan is even if you were wrong and you should not have used it, you can still be found not guilty. But it has to be reasonable and it has to be honest. And the reasonableness is really what gets people. It has to be reasonable. In your particular scenario, you're on your property, it's dark, you're a woman, you yell out. So that would be reasonable.
Now, second, the defendant must have been afraid of death, serious physical injury, sexual assault. Okay. Now, the jury instruction talks about this. You can consider to the jury the condition of the people involved,
Yes.
including their relative strengths and weaknesses, whether the other person was armed with a dangerous weapon or had some means of injuring the defendant, the nature of the other person's attack or threat, or whether or not the defendant knew about any previous violence acts or threats made by the other person. So basically, that's a lot that you can bring out to show, hey, look at this. Is that correct?
That is correct. So if you have a history with the person, or you know the person to be a bully, you know the person to carry a gun, you know the person to be violent, if you testify that allows you to use self-defense.
Wow. So you can basically talk about things that have nothing to do with this particular episode,
Correct.
incident.
Yeah.
So you mean to tell me, let me understand this, attorney. I can talk about the person that maybe I killed, them carrying a gun 6 months ago, them bullying 6 months ago. So time is not relevant?
No. Only thing that's relevant is you have to have actual knowledge of it.
Okay.
It can't be something that you heard through a third party. If you didn't seen the person with a gun, you didn't watch be violent with someone, you have to have actual knowledge of it.
Now, this is the one that you say gets a lot of people. Not only when you must have acted, had an honest and reasonable belief, it must be immediately necessary. Let's talk about that.
So it has to happen. So many times people will threaten people, and then something happens later, and then they say, well, I'll use self-defense. That's not self-defense. You can only use self-defense if the threat is in front of you. Threat is happening now.
And the jury instruction talks about imminent
Yes.
death or imminent great bodily harm or sexually assault to you or someone you know. What's imminent mean?
Immediate. It means that it's about to happen. So if you're in an argument with somebody and you walk out the door and then you come back in, you're not going to win on that one. It's about to happen right now. You have no time to leave. You have no time to escape. It's about to happen.
Somebody calls you. I'm going to kill you when I see you.